Bismillah, alhamdulillah, salatu salamu ala rasulullah wa ala alihi wa sahbihi wa man wala, thumma amma ba'd. To proceed. Today, inshallah, we will go over the second minor legal maxim. Second minor legal maxim, التابع تابع. التابع تابع. And I chose the dependent follows. The dependent follows. التابع التابع means what? التابع means the secondary, the subsidiary, the dependent, the follower. So when you say التابع تابع, it means the follower is the follower, or the follower follows, I guess. You know, in Arabic, one of them would be a noun and the other one would be an adjective. So the second one is an adjective. So it will literally translate as the follower or something. What does that mean? You know, just like to give you like one example quickly so that like you don't get lost. What that means is that if you have a contract, the contract has a primary subject matter and has secondary clauses. The secondary clauses in the contract will follow the primary subject matter of that contract. Quickly, but we will go over what it means in much detail. So whatever exists as a subsidiary to something, if it is not independent, follows it in ruling as well. So if it follows it ontologically, wujudan, it follows it hukman, in ruling as well. It does not precede it, it lapses when it lapses, and dispensations are granted in that which is subsidiary that may not be granted in the principle, And we will take so many examples, so everything, inshallah, will be very clear. This is a big one, just like the previous one, al-i'mal awla min al-ihmal, which means what? How application is preferred to neglect is how we translated al-i'mal awla min al-ihmal. Application is preferred to neglect. And in al-i'mal awla min al-ihmal, we said that there are so many subsidiary maxims under this one. So in this, these maxims look like the major ones because they have branches. They have many branches. And that's why I started by these two. And I told you that even al-i'mal awla min al-ihmal, some of the scholars said that it actually does not belong to the minor maxims. It should be the sixth major maxim. But these are big maxims, and that's why these are the only two that we will split between two classes. We'll divide over 2 sessions, these two. The last one we covered in 2 sessions. This one we will cover in 2 sessions as well. The minor legal maxims that will follow, we will cover, you know, sometimes 5 of them in 1 session. So what are the branches of this one? The first one is يثبت تبعا ما لا يثبت استقلالا. What cannot be established independently may be established as a subsidiary. يغتفر في التابع ما لا يغتفر في المتبوع. Dispensations are allowed in the subsidiary that are not allowed in the principal. قد يغتفر في البقاء ما لا يغتفر في الابتداء. In continuation, what would not be allowed at the outset or initiation may be tolerated afterwards in continuity. May be tolerated afterwards in continuity. And I started here by qad, and if it is not in your document, then it will come. You know, I corrected it because I felt that qad should be added, which means may. And whenever we say qad, is it justifiable to make it a maxim and to start a maxim by قد يغتفر في البقاء ما لا يغتفر في الابتداء. In continuation, what would not be allowed at the outset or initiation may be tolerated. can you start a maxim by qad, may? The scholars disagreed, and many scholars said no. It disqualifies it from being a maxim. It disqualifies it from being a maxim, because a maxim should be consistent. And if you're telling me qad, you're disproving yourself. Like what are you talking about? You're calling it a maxim and you're starting by qad, maybe. What kind of maxim is that? Okay, why am I including it as a maxim here? Well, first of all, we're including it in the subsidiary ones, and I pointed this out somewhere. Like somewhere I did point out, I did address that issue, that I will be using maxims that start by qad, because what I am looking for here is the point that the maxim is trying to make. I am not saying that this is consistent, that this will apply all the time, but maybe another way of phrasing this maxim, another way of phrasing it, to call it a maxim, and instead of saying قد يغتفر في البقاء ما لا يغتفر في الابتداء, in continuation what would not be allowed at initiation may be tolerated, maybe we can say that more tolerance or more lenience is basically shown in continuation or than initiation, something of that nature, to basically, highlight that point. If you already started, if you already started your Hajj, then I will be more lenient with you than if you have not started yet. If you already got your mortgage, then I may be more lenient with you than if you had not gotten it yet. Stuff like this. Okay. So, التابع يسقط بسقوط المتبوع, the subsidiary lapses with the lapse of the principal. The subsidiary lapses with the lapse of the principal. And then we have an exception from this one. And that's why I want you to be alert that, some of these maxims are not maxims in the literal sense. Because the exception from this one says, قد يثبت في الفرع دون الأصل. The branch may exist without the principal. So that basically tells you the opposite of the al-Qa'ida. التابع يسقط بسقوط المتبوع, the subsidiary lapses with the lapse of the principal. And we will take examples for each one of these so they'll be quite clear. من ملك شيئا ملك ما هو من ضرورته. Whoever owns a thing owns also what's necessary for it. التابع لا يتقدم على المتبوع. The subsidiary does not precede the principal. The subsidiary does not precede the principal. ما بني على الباطل فهو باطل. And this is proverbial, in people in our countries all the time. ما بني على باطل. Whether they know what it means or not, it's just they usually use it. It's proverbial. What is built upon falsehood is in itself false. Now, a quick evidence for this maxim. The Prophet ﷺ said, من ابتاع رخلا بعد أن يؤبر فثمرتها للبائع إلا أن يشترط المبتاع. Right? So, what this means is, whoever purchases a palm tree after it has been pollinated, its fruit belongs to the seller unless the buyer stipulates otherwise. So I am selling you palm trees. I'm selling you palm trees that have been pollinated already. So it is in a later stage of development. Have not ripened yet, but have been pollinated. We know that we cannot sell fruits before they ripen, right? Okay, we're prohibited from selling the fruits before they ripen. Now, I'm selling you the palm trees. They have been pollinated, but the fruits have not ripened yet. Is it okay to sell the palm trees with the fruits? Yes. Yes. The Prophet is saying it will go to the seller. The fruits will go to the seller, not the buyer. But the Prophet is saying it is allowable for the buyer to stipulate otherwise. The buyer can say, I get the fruits. The fruits have not ripened. But the Prophet is allowing this. Why? Because the sale of the fruits here is secondary or primary, subsidiary, secondary. You know, as we said before, the subject matter of this contract is what? The primary, basically, subject of the contract is what? The palm trees, not the fruits. So I am adding the fruits as a subsidiary. Therefore, what I would not allow for the sale of fruits, if they are the primary subject of the contract, I am allowing now because they are secondary, not primary. Okay, that's the evidence from the Sunnah. The basic rule here is that it's impermissible to sell pollinated fruit before it ripens. We've already explained this. Okay, now let's take some applications. One of the clearest examples here is the sale of a fetus in the womb of a sheep. Can you sell a fetus in the womb of a sheep? Can you? You know, it's unallowable. It's impermissible. Why? Gharar, undue risk taking. Gharar, uncertainty, undue risk taking. Gharar. What is there? Like, we don't know. Can you sell a pregnant sheep with a markup, like increase because of being pregnant? Yes. So in effect, you're selling the fetus because you added to the price of the sheep the value of the fetus. Isn't it true? But it's still permissible. Why? Because the fetus here is the dependent, the follower, the secondary, the subsidiary. It's not the primary subject of the contract. Okay. Yeah. Yes. Instead of $100 for like as a comparable sheep, this pregnant one you're buying for 120 because it's pregnant. In the invalidity of prayer on roofs of places where prayer is not valid. This is a Hanbali thing. So, but praying on top of like a restroom, for instance, praying on top of ma'atin al-ibil, resting places of camels and stuff like this, where prayer is not valid, prayer on top is a problem. Well, that's why in modern buildings, it's a little bit of a problem because the airspace follows the ground. Airspace takes the ruling of the ground. So everything, all the way up to the heavens, takes the ruling of the ground because it's taba to the ground. Anyway, but this is a Hanbali thing. Prayer of a follower is invalidated by the invalidation of the Imam's prayer. So in Hanbalism, in the authorized view of the madhab, if you are the Imam and you break your wudu, there is no istikhlaf, there is no succession. You don't grab someone and make them lead the prayer. All of our prayer is invalid. All of the prayer is invalid of the Imam and the Ma'mumeen. Because if my prayer has been invalidated, I'm the Imam, my prayer has been invalidated, all of your prayers are invalid. That is the mu'tamad, the authorized view in the Hanbali madhab. But that is not what most contemporary Hanbalis do because they follow the majority in the permissibility of istikhlaf. I break my wudu now, I bring someone to lead in my place, and you guys carry on, and I go make my wudu and come back. But Hanbali-wise, that is not appropriate. That's not permissible. I break my wudu, all of your salah is invalidated. Now, sujood al-tilawa. Sujood al-tilawa is also another example. The listener does not prostrate if the reciter does not prostrate. And that's why I have told you before that when you hear like a sajda al-tilawa, the prostration of recitation on the radio, you don't prostrate. Because you prostrate as a follower if the reciter himself prostrates. If the reciter does not prostrate, you do not prostrate. The 2 rak'ahs of tawaf during times of prohibition is another example. When you go make tawaf, don't we have certain times during the day when it is prohibited to pray? You know, after Fajr until sunrise, a little bit after sunrise. You know, right before Dhuhr and after Asr, particularly before Maghrib. So these are the five times, 3 of them are very prohibited. What if you go and make tawaf, and after the tawaf you're supposed to make 2 rak'ahs, rak'ata at-tawaf? Do you still make them in the times of prohibition? Yes, yes. Because of tawaf, if the Prophet ﷺ, you know, said don't prevent anyone who comes to make tawaf in any hour of the day or night from making it, so he allowed tawaf at any time of the day, then the subsidiary, the secondary, the follower, the tabi' of tawaf is what? The 2 rak'ahs that you pray after tawaf. Then they will also be allowed, they will take the ruling, assume the ruling of tawaf in being permissible at any time of the day. And whoever holds, you know, in the madhab, whoever holds the trees follow the land in ownership, this is the basis upon which they make that position. They take that position or uphold that position. So trees follow the land in ownership. If there is a dispute over a land, like I have, you know, my hand on a land, and then we get into a dispute over the land, and you prove that the land is yours, then the trees will be yours as well. And then, but controversial in the madhab. And whoever growth of pledged property also, if I basically pledge property, rahan, if I give you a goat as a rahan, like I borrow money from you and I give you my goat as a rahan until I pay you back, and the goat gives birth to another goat or the sheep, then that baby goat will stay with you, will not come back to me, because it will follow the ruling of the mother goat. Okay? Hopefully. It's subsidiary. And of course, we're talking here about separate growth. If it's inseparate, then of course, you know, the goat became fatter, you know. So the goat now, like when I borrowed money from you, I gave you a goat that was worth $60 to keep as security until I pay you back. The goat became much fatter. The goat now is worth $120. Can you ask me for half of the goat? No, of course, it's the same goat. But even if the growth is separate, birth of another goat, the growth is separate, the secondary follows the primary. Both goats stay with you as the murtahin until, yes. Well, that is another one of the mufradat of the madhab, the peculiar positions of the madhab. For us, you benefit from the milk. If you're feeding the goat, you benefit from the milk. But that's a Hanbali thing as well. So the Hanbalis try to make life a little easier here. So they say, instead of, you know, the rahin being responsible for feeding the goat and the rahin being entitled to the milk of the goat, you as the murtahin, as basically the creditor, and you know, can feed the goat and milk it and benefit from the milk and just get it over with.
Lamb goes person who fed it or goes with the owner?
No. It will stay with the murtahin. It will stay with the murtahin. That's the pledgee, I guess. Will stay with him until you pay me back. You give me your sheep because I lent you money. When you pay me back, I'll give you your sheep back.
Plus the lamb.
Plus the baby lamb that was born. I'll give it back to you, but I'll keep it as long as you have not paid me yet back. Okay? Because it stays with the principal, her mother. Okay. And then admission of trees is, admission of the ownership of trees is not admission of the ownership of land. You could have a tree that you own on a land that you don't own. You can plant a tree on a land that you do not own, and the tree will be yours. Admission of the ownership of trees is not admission of the ownership of land, but admission of the ownership of land is admission of the ownership of trees. Because what is the primary here and what's the secondary or subsidiary? The land is the primary, the trees are the subsidiary. So in the Hanbali madhab also, and that's when usul and qawa'id overlap, any address to the Prophet ﷺ includes us or does not include us? When Allah subhanahu wa ta'ala addresses the Prophet directly in the Quran, does that include us by default or not? It's a matter of controversy. And in the Hanbali madhab, it does address us by default, unless proven otherwise. The majority said, and that includes some Hanbalis, like Abu al-Hasan al-Tamimi, I think, and Abu al-Khattab, they said it doesn't include us until proven otherwise. So it doesn't include us until proven otherwise if it is addressing the Prophet ﷺ. يا أيها المزمل قم الليل إلا قليلا نصفه أو انقص منه قليلا أو زد عليه ورتل القرآن ترتيلا. Does that include all the Muslims or the Prophet alone? We say it includes everybody until proven otherwise. They say it doesn't include anybody until proven otherwise. Okay. In our own time, everything, so like a quick application here, quick modern application. If you sell a car, you sell everything that comes with the car because it will be subsidiary to the car. So everything that comes with the car will be part of the contract, even though the contract did not name those things. But things that are customarily included will be part of the contract. So exceptions. What if, in our madhab, we said that if I break my wudu during the salah, this istikhlaf or succession is not allowable. The majority said allowable. We said not allowable. What if I don't have wudu and I discover that I didn't have wudu after the prayer ended? Huh? Salat al-Mu'mineen sahiha na'am. So, if I discovered after my prayer ended, then your salah is valid. Your salah is valid. Is this an exception from the? Yes, it's an exception here. That's why we're discussing this under exceptions. Because how come? My salah is invalid. I have to repeat the salah because I discovered after the salah ended that I did not have wudu. But since all of you did not know this, all of you, not only some of you, all of you, ma'mumeen, did not know that I did not have wudu, and you prayed and you finished the prayer, then we will validate your prayer. Okay, this is like a little bit of sort of mental gymnastics. So if you say, for instance, when we talk about the contained and the container, if you say I owe him dates in a bag, a sword in a sheath, a gem in a ring. Does that constitute as an admission of owing him the dates and the bag, or only the dates? The stone and the ring, or only the stone? The sword and the sheath, or only the sheath? Eventually, in the madhab, it will be an admission only of the contained and not the container. So the container will not follow. That's why I included it under exceptions, because this is an admission of the sword, not the sheath. The dates, not the bag. Certainly, with a little bit of change and the phrasing, it will be an admission of both. A little bit of change will be an admission of both. Such as like a sword with a sheath, not in a sheath. You know.
It's embellished.
Huh?
What if it's embellished? Has value.
If it is, so there are two different ways of distinguishing, there are two different ways that will basically take a little bit more nuanced approach to this discussion. The first one is, but that's not the madhab, but some later scholars said, if it is ordinarily or naturally connected, then the admission extends. If it is ordinarily or naturally connected, then the admission extends. Another way to look at this and to distinguish between the different scenarios is if the second is a subsidiary, it's included. If the second is the principal, it is not included. So dates in a bag or a sword in a sheath, if you say pits and dates, or the head of a sheep, I owe him pits and dates, or the head of a sheep. What is the primary and what's the secondary? The pits or the dates? The pits are secondary. The primary, okay. If you say I owe him pits and dates, you're not acknowledging the dates, you're only acknowledging the pits. And if you say I owe him the head of a sheep, you're not acknowledging the sheep, you're only acknowledging the head, because it's primary and secondary. But if you say a sword in a sheath, what's the primary and the secondary? The primary is a sword, the sheath is secondary. They would say the admission, the acknowledgement will extend to the sheath, will extend from the dates to the pits, not vice versa. Will extend from the sword to the sheath, not vice versa. Anyway, this is for judges that will have to make, tough determinations. Like people can have all kinds of funny disputations, and you can get like these scholars. The beauty of this is that these scholars were judges. These scholars were judges, or they were muftis that are getting inquiries from judges, and they have. We talk about the guy who said to his wife, I give you 1/6 of a divorce. It's not frivolity of on the part of the scholars. They get those questions, so they have to have answers for them. So next would be يثبت تبعاً ما لا يثبت استقلالاً. So we're done with the primary, the mother qaida. Let's take some branches. يثبت تبعاً ما لا يثبت استقلالاً. That's the القاعدة السعدية ال15. So what cannot be established independently may be established as a subsidiary. So Ibn Rajab said in his 133rd qaida, what cannot be established independently may be established as a subsidiary in various cases. such as if women testify regarding childbirth. One testimony of a woman that she breastfed someone can be decisive, can end the marriage. Because her testimony of breastfeeding is the primary one. Secondary, the subsidiary to this, is that if I testify that I fed this person and I fed that woman, they cannot be together. They cannot be married. So one testimony of a woman, would be decisive here. Same applies to childbirth, although if a woman comes and testifies that this baby is the child of this man, is lineage established? No. But this woman says this baby was born, like I have witnessed the birth of this baby to the wife during their marriage of this man. Is lineage established? Yes. So, because it's secondary to her testimony about childbirth. And why are we accepting her testimony about childbirth? Because naturally there wouldn't be a whole crowd in the room. Nowadays in hospitals, it's a party. But usually that used to be a little bit more private in the past. Anyway, if one woman testifies to miscarriage having occurred, like if she says that the blow caused the blow to that pregnant woman's tummy had caused this miscarriage, then that is enough for us to make a determination about compensation. So if she says that the baby was stillborn, what will be the compensation? Ghurra. That's the compensation by a slave. So what is the compensation if the child was born alive? Full diya, the full diya of a human being, or blood money. Full diya, yes, born alive, but he died after birth. Yeah. Then, if one person informs of sunset, do you break your fast? Yes, because we're considering the breaking of the fast here subsidiary to what? To the Salat al-Maghrib. So is Salat al-Maghrib, is one person testifying to sunset enough for us to pray Maghrib? If it is enough for us to pray Maghrib, it's enough for us to break the fast. If one person testifies to sighting the crescent at the beginning of Ramadan, one person testifies to sighting the crescent, and then 30 days go by and we don't sight the crescent of Shawwal yet. After 30 days, we didn't sight the crescent of Shawwal. Do we go by, so this is the beginning of Ramadan, one person sighted the crescent. One person. At the end of Ramadan, after 30 days, because Ramadan cannot be more than 30 days. Okay, so after 30 days, we have not sighted the crescent of Shawwal yet. Do we end our fasting or not? No. In the madhab, no. But if you go by the qaida, those in the madhab who said we end our fasting will base their judgment on what? At-taba'. So, we started, or يثبت طبعا ما لا يثبت استقلالا, which is a subsidiary of at-taba'. We started Ramadan. The end of Ramadan is subsidiary to the beginning of Ramadan, and Ramadan cannot be 30 days, so we will have to fast. The madhab will say, since Ramadan started by testimony in the madhab, Ramadan starts by the testimony of one and ends by the testimony of two. In the madhab, Ramadan starts by the testimony of one, ends by the testimony of two. They will say, since it started by the testimony of one, we will not end it just simply by the completion of 30 days. We want to see the crescent. Now, if the prayer, okay. Yeah, it could happen. But keep in mind that usually it would not be like if two people cited it at the beginning of the month, 30 days go by, we will end our fasting. Because we started our fasting by the testimony of two. We're just talking here about starting our fasting by the testimony of one. Ramadan starts by the testimony of one, احتياطاً للعبادة. So to be on the cautious side, someone says, I sighted the moon, like the Bedouin man who came and said, I sighted the moon outside of Medina, and the Prophet ordered everybody to fast. Someone says, I sighted the moon, we'll start to fast, out of respect, reverence for Ramadan. We can't afford to miss a day of Ramadan. But if one person at the end of Ramadan said, I sighted the moon, okay, we will tell him we need another one to break our fast. We need another testimony to break our fast. The problem happens when we begin Ramadan by the testimony of one person, and then 30 days go by and we don't see the crescent. And then we'll be in trouble. So anyway, so we will disagree. And the madhab will say, don't break your fast because you started it by the testimony of one person. So be cautious, have reverence for the, okay. No. If you had two witnesses to start, you do not need any witnesses after 30 days. You will need the two witnesses after 29 days. But after 30 days, you don't need witnesses. Okay. It will not happen that you will not see, because you will go back, and at one point you will go back to the previous month, and one of these months will have started with two witnesses. So from here to here, the 2 months cannot be more than 60 days. So you end after you have confidence that Ramadan must end now. The problem that we had here, is that someone after 29 days saw the beginning of, sighted the moon, the crescent, and we started to fast because someone said, I sighted the crescent. It's just one person. And then 30 days go by, and we don't have a sighting. But this is an example where this is قواعد فقهية. It's not fiqh. قواعد فقهية, legal maxims. Huh? No, not really. Anyway, so can you pray on behalf of someone No. No, and according to the very vast majority, because al-a'mal as-salihah, righteous deeds, can be done on behalf of someone. Many of them can be done on behalf of someone. So you can make hajj on behalf of someone. Fasting is like a lot of controversy, but you could make fasting on behalf of someone according to the majority. You could basically, of course, sadaqah, you could give sadaqah on behalf of someone. All of that is fine. Can you pray on behalf of someone? No, you can't. And that is according to the, can you recite Quran on behalf of someone? Yes, the majority will say yes. Yeah. So, but the issue here is, can you pray on behalf of someone? The very, very vast, overwhelming majority of scholars said no. But what if you make hajj on behalf of someone and you pray the 2 rak'ahs of tawaf on their behalf? That's fine. That's valid. Why? Because it's subsidiary. Okay. Yes. So the agent or the guardian of an orphan, can they give a gift from the orphan's money? The agent or the guardian of an orphan, can they give someone a gift from the orphan's money? No. Can they buy something for the orphan at a higher price than usual? Can they be a little bit more generous in compensation? Yes. So what is the difference? It seems like the difference in price is a gift they gave to the seller, because it's taba, it's subsidiary to the sale contract. We have another big issue, which is like, when can we sell the fruits of an orchard? When can we sell the fruits of an orchard? We started this discussion by talking about, the fact that we're prohibited from selling fruits before they ripen, unless, of course, there is a caveat, and everything has a caveat. Caveat here is if the fruits will be harvested before they ripen for a known usage. People use them unripened for something. Okay, so we can't sell the fruits before they ripen. Do we have to wait until every fruit in the orchard ripens before we sell the fruits of the orchard? No, we don't. We don't. So, by agreement, the fruits of every tree, if some of them ripen, the rest of the fruits on the tree can be sold. The rest of the same type of fruits in the orchard can also be sold. This goes as far as what? As far as a position outside of the madhab that Imam Taqiyuddin adopted after Layth ibn Sa'd, that the fruits of any genus in an orchard will be sufficient, the ripening of the fruits of any jins, not just type, not just different types of dates, but between one genus and another. The fruits of the ripening of the fruits is sufficient to sell the whole orchard with all the fruits in the orchard, different fruits of the orchard, because everything, apples and oranges. Why? Because they said that amn al-aha is what matters. Amn al-aha is what? That you've made sure that no aphid or no calamity will befall the crops, so that we're past the that threshold. But anyway, this position is not the position of the madhab, not the position of the madhab. But Imam Taqiyuddin used to be very flexible in transactions to validate, try to validate many transactions as possible. Okay. So there is another good example. The case of mudd ajwa. One mudd is what? Yeah. So yeah, the amount of whatever food or like wheat or something that you can have in your two hands of an average adult male. They disagree over this all the time. And people write books about this, by the way. Books. But anyway, is likely anywhere from 0.51 liters to 0.75 liters. One mud is anywhere from 0.51 liters to 0.75 liters. So 1 sa' will be 4 times this. Then 1 sa' will be multiply this by 4, and then you will get the 1 sa'. If I say to you, okay, it's not valid to sell any ribawi item for its like, with one or both of them combined with something else of another kind. 1 mud of ajwa and a dirham for equivalent, or 2 muds or 2 dirhams. So 1 mud of ajwa, 1 mud of dates, ajwa dates. Forget about the ajwa. The ajwa itself is not a problem. 1 mud of dates, and a dirham. Can I exchange these for 1 mud of dates, 2 muds of dates, 1 mud of dates and a dirham, 2 muds of dates, or 2 dirhams? No, I can't do this exchange. One of them, these are ribawi items, and I have to ascertain what when I exchange ribawi items. Equal for equal, hand to hand. Equal for equal, hand to hand. Can I make this? Can I ascertain this? No. Therefore, what is it? Okay, what can I do? Separate the safqa, separate this, sell the 1 mud of ajwa, separate from this, and don't combine them in this way. But what if I have a home with gold embellished ceilings? Can I sell that home for gold? Because here, this is home and gold for gold. Can I do this? Yes, because the gold on the ceilings is not basically primary, it's not intended to begin with. It is trivial, negligent, not intended in and of itself. I am buying the home, I am not buying the sort of gold embellished ceilings or the gold embellishment in the ceilings. Okay, now how do we apply this to something in contemporary reality? Yes. Okay, warranties will come when we talk about يغتفر في التابع ما لا يغتفر في المتبوع. That more tolerance or lenience will be extended to the subsidiary than the principal. It belongs to this discussion, but I'm talking about this particular example that I talked about, the 1 mud of ajwa, the ceiling, stocks in the stock market. What is it that you're buying when you buy stocks? You buy a piece of the company. What does that include? It includes a percentage of every asset in the company. What does that include? The cash surplus. They have cash. The company has cash. So stocks would be cash. The company, what are the assets of the company? Cash, headquarters, cars, buildings, factories, furnishings, all of that. You're buying all of that by what? What are you paying? Cash. So here's a problem. And how did they justify this? It is cash for cash and something else. Cash is a ribawi item. You can't do mudd ajwa and a dirham for 2 mudds of ajwa or for 2 dirhams. Okay? 2 dirhams, 1 dirham, 1 mudd of ajwa. You cannot do that. Okay. How did they justify the trading in stocks? تابع تابع. يثبت تبعا ما لا يثبت استقلالا. So we can validate this in this way. Palm trees, not least in the madhab. Palm trees, keep in mind that you may say that this also belongs to يغتفر تبعا ما لا يغتفر استقلالا, because they are interconnected. All of these rules are interconnected. So I showed more lenience here to this transaction, because the cash in this transaction is basically not intended for itself. When you buy Apple stocks, you're not buying the cash surplus that Apple has. You're buying, a part of Apple, with everything that means, not necessarily the cash that they have in their bank account. Okay, palm trees, the leasing of palm trees in the madhab, yes. Private. Yes, if it can be done, then we ought to, yes. Palm trees, not least in the madhab, so why is it that we don't approve of leasing palm trees in the madhab? Why do people lease palm trees? For the fruits. Okay, so that, don't we say that you can't sell fruits before they ripen? So if you lease the palm trees, you're in effect buying the fruits of the palm trees before they ripen, right? I lease the palm trees to you for 5 years. What does that mean? What am I after? The dates. Okay, so in effect, I am buying the dates for 5 years. Hard to get. Okay, so Imam Taqiyuddin said that it is okay to lease palm trees because the fruits in this case will be taba, subsidiary to the palm trees. And he said, this is established from Umar, that he allowed it, and he responded to the use of the hadith about not selling fruits before they ripen.